Welcome everyone. My name is Kate Zulo. I'm the educator here at Litchfield Historical Society. Welcome to tonight's lecture, which is on the law of slavery. And we have really excited that we have Professor Justin Simard with us tonight. He is an assistant professor at Michigan State University College of Law, where he teaches professional responsibility, legal history, and commercial law. He received his bachelor's degree in history from Rice University and completed his JD and PhD at the University of Pennsylvania. His research focuses on the relationship between lawyers and economic development. And his recent work analyzes how the commercial role of lawyers brought them into direct contact with the law of slavery and how this encounter supported slavery and shaped the development of the profession of the law. Now, of course, when Justin was at the University of Pennsylvania, I believe, he had his first trip up to Litchfield, which everyone at the Litchfield Historical Society at the time remembers fondly. So, Justin, of course, since you're coming into us virtually, your trip here tonight isn't quite as memorable, but we are still absolutely delighted to have you joining us here tonight.
All right, well, thank you, Kate, for the introduction, and the Litchfield Historical Society for inviting me to speak. And thanks all of you for attending. So as Kate mentioned, I'm really excited to share my work here because the roots of this project date all the way back to my second year of graduate school when I drove a motorcycle with undiagnosed electrical problems up to Connecticut from Philadelphia. To do research at the Litchfield Historical Society. It was really the first big research project I was going to do as a graduate student. My motorcycle broke down, I think 20 or 30 miles south of Litchfield, and I had no cell phone service, so I knocked on a random person's door who luckily was working from home. And she drove me up to Litchfield and in a very auspicious sign, not only volunteered to drive me up, but also gave me a tour of the town. I thought that was a pretty auspicious sign, as was the excellent hospitality everyone at Litchfield Historical Society showed me. I'm pretty sure that, if I remember correctly, Kathy's husband drove me back to fix my now not broken motorcycle so I could return to Philadelphia after my initial trip. So let me just share my screen here with you. Today I'm going to tell you a story of that a sort of similar, interesting, and surprising route led me to, a project that reveals that American judges and lawyers continue to cite slave cases, that is, cases involving human property, as good law. So I'm going to first introduce this issue by providing a sample of a modern citation to a case rooted in slavery. Then I'll take us back to the Litchfield Law School to explain how lawyers built and operated the law of slavery in the 19th century. Next, I'll discuss the continuing law of slavery, explain the prevalence and harm of the modern citation of slave cases. And finally, I'm going to conclude by examining how lawyers can work on redressing this law of slavery by taking guidance from other movements addressing slavery's legacy and by trying to correct some of the faults shared by Litchfield's lawyers and lawyers throughout and their successors. So rather than talking for the entire hour, I'm going to try to leave plenty of time for questions. So if it's something you'd like me to expand on, I have lots more material and I'd love to hear your questions and thoughts. So I first came across the modern citation to cases involving human property by chance in the course of doing my research on Southern alumni of the Litchfield Law School. So in particular, I was interested in this guy, Eugenius Aristides Nisbet. And I can't lie, part of it was because of his very interesting name. He attended Litchfield in 1823 and then returned home to his state of Georgia, where he established a prominent place in the Georgia bar and served as a justice on the Georgia Supreme Court. He also made a lot of money as a lawyer. Now, this offshoot of the project started when I was using Westlaw, which is a legal database, to research the influence of the opinions Nisbet authored when he served on the Georgia Supreme Court. Now, I wanted to show that these opinions were cited by Northern lawyers even in the 1850s when sectional tensions were especially high. My thinking was that even at that time, there was this sort of American legal culture, a shared core of American legal culture that Northern and Southern lawyers could both identify with. Now, not only did I find what I was looking for, I found plenty of Northern judges who were citing his cases. I also found that some of Nisbet's opinions, even some of his cases about enslaved people, have been cited by modern judges and lawyers in the last few years. Now, I was surprised, especially because I knew that courts, as a general principle, rarely cite 19th century cases. I thought I'd find just a few examples of modern citations to cases involving enslaved people. And I thought even those few examples, if I could just find a couple, would be worth writing about. My research, however, has turned up more than 350 cases in the last 35 years in which state and federal judges from Alabama to Wyoming have cited cases involving enslaved people in a wide variety of subject areas, from contract to criminal procedure. So let me give you an example. This is a citation to one of Nisbet's cases. In 1994, the United States Court of Appeals for the Eighth Circuit was handling a case brought by Richard Joseph Belk, a prisoner who argued that he had not been given proper hearing before his parole was revoked. In particular, Belk claimed that his constitutional rights had been violated because he had not had an adequate opportunity to confront witnesses at his parole hearing. The opinion in that case quoted from one of the opinions Justice Nisbet had authored in 1846 in his first year on the Georgia Supreme Court. The judges cited Nisbet's opinion for the following statement, which is on the slide, but I'll read it because I know it doesn't always translate on Zoom. The right to be confronted with the witness and to sift the truth out of a mingled mass of ignorance, prejudice, passion, and interest, in which is very often hid, is among the various strongest bulwarks of justice. Now, this proposition is uncontroversial. The right to confrontation is a key protection provided by the US Constitution and protected by US courts. The case where Nisbet included these inspiring words, however, he didn't write them. He wasn't as flowery as a writer. He quoted these, although the quotation wasn't acknowledged in this modern citation. The case in which he wrote these words, included these words, was a dispute over the ownership of an enslaved woman named Amy and another enslaved woman named Melinda, who was either her granddaughter or daughter. In that context, the praise of such important rights strikes a hollow note. Why would the court choose to rely on this case for an uncontroversial legal proposition? And why didn't it recognize that the case grew from slavery? Let me give you another example where the court did recognize the slave context of the case, but decided to cite it anyway. This is not one of Nisbet's cases, but from another 19th century judge. So this example of the citation comes from a 1999 case in the Tennessee Court of Appeals. In this case, the court faced a really simple question of law. Could a jury award damages both for loss of use and for decrease in market value for injury to personal property? So the suit was brought after someone was renting this tire shredding machinery and a fire destroyed it. And so basically they were suing the person who was renting it for damages. And the question was, could they recover damages just for how much money they would have gotten for renting out the machine? Or could they recover damages for the loss of value of the machine because of the fire damage? Or could they cover both kinds of damages? Now, in coming to its decision, the Tennessee Court of Appeals cited Johnson v. Perry, an 1841 Tennessee case involving an enslaved person, a man who is himself considered damaged property. Now the court, and this is from the 1999 case, the court cited this case because it was the first opinion to explain what damages were available for injury to personal property in Tennessee. It analyzes this case about damage to human property like any other case. So it says as follows. The court held, this is recounting this 19th century case, the court held that if injury had been temporary, the plaintiff could recover damages for the loss of the slave's service. If, however, the slave had been permanently injured, the plaintiff could recover damages for the deteriorated value of the slave in lieu of damages for loss of service. Finally, if he had been killed, the plaintiff would have been entitled to damages equal to the actual value of the slave, but would not have been entitled to recover damages for loss of the slave's service. So here it is, a court in 1999 citing a slave case and treating it just like they would any other case. In fact, the next citation is a case about damage to a car. But of course, Johnson v. Perry, the case that the Tennessee court cited, did not involve a car. It involved David, who was an enslaved man in Tennessee. Now, David's case arose out of a verbal altercation between him and a group of white men. They seized him in the midst of this altercation, likely fearing for his life. He freed himself and jumped off a 4-foot ledge into a creek, ultimately and severely and permanently injuring his leg. Now, the court blamed David for his own injury, and they compared him to a frightened animal. But they ultimately awarded damages to his owner who brought the suit. The treatment of David, Amy, or Melinda as pieces of property was, of course, a natural result of slave commerce. But treating cases like this as regular law today, I don't think makes sense. So at a time when other American groups and institutions, from businesses to universities, are attempting to reckon with the legacies of slavery, I think lawyers need to do the same thing. So this project asks lawyers to do 3 things. First, lawyers need to recognize and acknowledge the important role that the profession played in the development and maintenance of slave commerce. Second, courts need to recognize that even from a narrow legal perspective, they can't treat these cases like regular law. For one, they should note that these cases have been abrogated, at least in part, by the 13th Amendment, which bans slavery. Yet no court I've found has recognized that. They also need to consider the ways in which slave context makes a case less persuasive. Third, I think courts need to consider the serious dignitary harms of citing slave cases. Citing such cases without commentary ignores the humanity of those harmed by legal subjugation and treats slavery's legal architects as respected authorities. Such citation continues a pattern of dehumanization that crystallized in the 19th century. Now, unfortunately, Litchfield lawyers played an important role in making the conditions possible for such dehumanization. So that's what I'm going to talk about now. Now, at first glance, Litchfield seems like a pretty unlikely place for the law of slavery to take root. Connecticut was not only separated from the South by hundreds of miles, but also by a drastically different way of life. Nisbet and other Southerners left behind their plantation homes and an economy built on slavery for Connecticut, a state in which gradual emancipation had begun in 1784, and where men worked as small farmers or artisan manufacturers. One classmate of Nisbet's noted in his journal that he encountered white servants for the first time on his trip to Litchfield. And when Nisbet traveled to Litchfield, more than 40% of his state's population was enslaved. Nisbet himself had grown up surrounded by African Americans owned by his family. And he held an idyllic version of Southern slave society. So in his diary, he wrote that his father's slaves were part and parcel of the family. He claimed that he had loved them all and believed that they were happy, faithful, and attached. This was not a man who was conflicted about the institution. Litchfield's teachers, Tapping Reeve and James Gould, on the other hand, both opposed slavery. Reeve found slavery repugnant to reason and the principles of natural law, and he argued that it had to be explicitly ratified with legislation for it to be legal. In his lectures, Gould argued that slavery contravened both common and natural law. Both ultimately agreed, however, and this is very important, that slavery could be legalized if a legislature so provided, even though they opposed it. So though they were morally opposed, they thought slavery could be legalized as long as the legislature of a state made it so. Now, that said, you would imagine that maybe Southerners wouldn't want to learn from people who opposed the institution from which they would earn their livelihood, at least indirectly. But Reeve and Gould's criticism of slavery did not stop Southern students from attending Litchfield. They made up roughly 30% of the student body. Now, the ability of Litchfield to attract Southern students and to launch them into successful legal careers in the South illustrates the relatively low importance that both students and Reeve and Gould placed on the law of slavery as a subject of study and the value that they saw in less controversial legal subjects. So neither of Litchfield's teachers developed much attention to slavery in his lectures. A typical student's notebook, composed of more than 1,000 pages of material, included less than 3 pages on the fundamental law of slavery. Instead, Reeve and Gould educated their students extensively on more mundane and practical legal subjects from the rules of pleading to the law of evidence and agency. Now, as we'll see, those same rules and laws were helpful for those working in a slave context. But Reeve and Gould's lack of attention to the law of slavery, it may have reflected their reluctance to broach a politically charged subject. So that might explain why they only had a few lectures recorded on the topic. But it also indicates that they did not understand opposition to slavery as essential professional conduct. In other words, you could be a good lawyer and still support slavery. Even Reeve, who had argued in his own legal practice that slavery violated state constitution, believed that positive law could legalize a practice he resented. In place of a moral core, then, Litchfield offered, I think, a technical one. Now, this legalistic perspective classified slavery's problems as political rather than legal. As long as a simple act of the legislature could authorize slaveholding, slavery did not present interesting or important legal issues. From the perspective of a working lawyer, the law in this question was settled. A difficult question of law, even one involving a seemingly mundane subject such as law of debt, demanded more analysis. And so if you look at the Litchfield notebooks, they devote way more attention to things like debt and contracts, things that would come up a lot in the commercial legal practices of Litchfield lawyers. Now, this lawyerly view of the legal system characterized the Litchfield curriculum. They focused on the private legal rules that would prepare their students to practice in a legal world in which most lawyers earned a living handling commercial issues. As a result, Southern students lauded the school and its proprietors. Even John C. Calhoun, who spent many of his years in public life defending, justifying, and working to expand slavery, remembered his time at Litchfield fondly. In 1810, he wrote to Reeve to recommend a student for admission to Litchfield and express his gratitude for the many advantages he had received from Reeve's teaching. John Mason, a pro-slavery Virginian who had attended Litchfield in 1817, referred to Reeve's lectures as masterly productions and noted the decided advantage that Litchfield held over any apprenticeship. In 1822, when Reeve turned 70 and reached the mandatory retirement age for Connecticut judges, a group of his students organized a collection to help support their former teacher. 6 of the 10 men on the organizing committee lived in the South. The technical legal education that Reeve and Gould provided was exactly what Southern alumni needed to succeed in their legal careers. In practice, the technical, legalistic perspective learned at Litchfield and shared with lawyers educated elsewhere meant that lawyers like Nisbet could use their expertise to fit slave cases into long-standing legal categories that were shared with Northern lawyers. So in a sense, when Reeve was Reeve and Gould were educating all these other subjects, they were educating Southern lawyers how to use all those other subjects in a slave context. So let me give you some examples. The dispute of whether an agent had authority to sell and warrant an enslaved person was a matter of the law of principal and agent. The proper procedure for a sheriff seizing enslaved people became questions of debt and commercial relations. The assertion of title to borrowed enslaved people was a conversion of property. Cases like these relied on the same kind of legal reasoning and legal categories, contracts, share of sales, conversions, that Northern lawyers used in cases about non-human property. So in a sense, almost all of the commercial law that lawyers learned at Litchfield would become slave law. And it became it in a very big way. The work of Nisbet and other judges built a massive law of slavery. From commerce to criminal law to inheritance, slave-related disputes made up a significant portion of American dockets. Appellate case reporters contain almost 11,000 cases containing enslaved people. And loans secured by enslaved people in just one Southern state had the same value as 11% of bank capital in the United States. This was big business. Now, after Nisbet's service on the Georgia Supreme Court ended, he returned to a private legal career in which he devoted the bulk of his practice to collecting debt on behalf of creditors from across the United States. And this is a line of work that many Litchfield students fell into after, or at least in parts of their career after they left the law school. And his particular practice focused on collecting debt from faraway creditors, including a large number of clients in New York, which was the heart of American finance. Even in this work, he played an important role in helping slaveholders. For the most part, the loans grew from business transactions in which merchants sold goods to Southern purchasers on credit. Nisbet worked for purveyors of luxury goods whose products like cigars or wines allowed plantation owners to project their wealth and power and distinguish themselves from their poorer neighbors. Just as his work on the Georgia Supreme Court had helped regularize the law of slavery, this work helped integrate slavery into the mainstream of American commerce. So I have up here a letter from Nisbet's debt collection work. People would send these letters asking for collection, and he would go out and do it. Now, obviously this work is important, but what's more important, I think, is people knowing that there are people like Nisbet out there who could do this kind of work. So in a sense, if he's operating in the shadow of the law, and then these transactions are operated in his shadow as well, that makes sense. By facilitating collection, then, Nisbet and other lawyers encouraged Northern businessmen to sell their goods in Southern markets. If they couldn't have collected, they wouldn't have done it, and helped provide the fruits of Northern manufacturing and importation to Southern slaveholders. Translating slave commerce into law, as Reeve and many of his classmates did, as judges, lawyers, or both, of course, supported the slave system. Resolving basic questions of inheritance helped Southerners pass on the people they owned to their heirs. Mortgaging enslaved people allowed slaveholders to capitalize on their human assets and create a market for collateralized slave securities. Regulating the practices of hiring out enslaved people stabilized an active market. In enforcing inheritance laws, courts forcibly subjected the enslaved to appraisal, sale, and permanent separation from their family and friends. The purchasing power given to enslavers by slave mortgages increased their grip on political and economic power and heightened the risks of familial separation through a borrower's purchase or a lender's repossession. This work was critical to maintaining slavery. Now, despite the dramatic changes wrought by the Civil War, the abolition of slavery in the 13th, 14th, and 15th Amendments, for the most part, lawyers stuck to a legal approach that treated cases involving enslaved people as if they'd involved non-human property. So in 1871, the US Supreme Court ratified this approach, holding that outstanding contracts for payments for slave purchases were still enforceable even after emancipation. They continued, in other words, to treat these contracts like contracts for any other kind of property, rather than a piece of the now legal slave system. But this made sense because that's how they had always been conceptualized. These were not special slave sales, these were sales that happened to be of people. As a result of this, the world of slave commerce had been uprooted, but its legal legacy continued as part of US law. Nisbet, for his part, noticed the same thing in his practice. Despite his support for secession and the Confederate government, he actually drafted the Georgia secession ordinance. He had little difficulty rekindling ties with Northern clients just a few months after the Civil War ended. And although he viewed the local federal judge as a political radical, when he argued before him, he found him to be, quote, fair, unpretending, and respectable as to ability. As it had for most of his professional life, a devotion to legalism offered a lucrative way for Nisbet to overcome political differences. As long as judges and lawyers met the standards of professionalism, as long as they followed legal rules and continued to speak the same legal language, a unified legal culture will continue to function, even without a strong moral core. Now, this legalistic approach, handed down from their 19th century predecessors, has led most judges and litigants to continue to treat the slave cases that Nisbet and other Litchfield graduates helped create as good law, and to categorize such cases in these same standard legal categories that they did. This legacy lives alongside the legacy of racial slavery other scholars have observed in criminal law. Now, in my research, I have found citations of slave cases across the United States. I found at least one slave case in the records of each state that appears in red on this slide. So Connecticut, you lucked out. I also found cases in every federal circuit court and in the US Supreme Court. Roughly 80% of the cases I found that cited slavery did not acknowledge a case of slave context. So they were like that one I started with, where they cited to Nisbet's case involving an enslaved person, but didn't say this involves an enslaved person. Now, I think analysis of these cases without acknowledgement of their context creates two types of harm, legal harms and dignitary harms. So let's talk about the legal harms first. Slave cases required the court often to recognize that enslaved people differed from other types of property, right? You can't treat even a white supremacist judge can't treat an enslaved person like regular property. So these cases, therefore, can sometimes provide unclear precedent. For example, a case about slave hiring could be precedent for a case about renting goods or for employment law. And judges and courts have sort of used these cases for both purposes. Second, by citing slavery, judges risk relying on opinions focused on protecting slavery rather than reaching well-reasoned decisions. So at least some of these opinions were written in a climate in which the judge was more concerned about making sure slavery was protected than in reaching the right decision. Third, the 13th Amendment bans slavery, and lawyers need to recognize that the cases have been abrogated, at least in part. It only makes sense to continue to treat these cases, to cite these cases, if you continue to treat the people in them as property, but the 13th Amendment says we can't do that. This is related to the dignitary harms. First, by treating slave cases as normal precedent, judges disregard the white supremacist language and reasoning underlying these cases. Remember, David, the enslaved person, was compared to an animal, right? And basically blamed for his own injury when it wasn't his fault. Second, judges hide the role lawyers played in facilitating the slave system by not discussing the context of these cases. So they sort of whitewash it away, right? Third, they perpetuate the dehumanization of the law of slavery. So modern judges who cite these cases without commentary continue to dehumanize the enslaved people involved by treating them as property. Such dehumanization is evident in the use of slave cases as support for basic propositions of law. So let me give you a few more examples. In 2015, Justice Thomas, writing dissent, relied on a case about the inheritance of enslaved people for the proposition that the judiciary is the tribunal appointed by the Constitution and the law for the ascertainment of private rights and the redress of private wrongs. He thus decides to justify judicial power by pointing to one of the worst abuses of judicial power, its enforcement of slavery. The Maryland Supreme Court similarly failed to recognize the irony of using the 1862 case involving the sale of enslaved people as a lone source for justifying collateral estoppel, which basically is the legal principle that you can't dredge up matters that have already been decided. Only from a myopic vantage point does a case about the sale of humans serve as a legal rule on what justice requires and the public tranquility demands. Here's one last example, this one from the North Carolina Court of Appeals. They cited a slave case for the proposition that common law marriages cannot be created in North Carolina. Like these other citations, this too was inapt. The court denied common law marriage for specific reasons related to the context of slavery. Enslaved people, it noted, had the incapacity to enter into contracts, and marriage risked curtailing the rights and powers of masters. So the modern court, in 2012, in other words, is citing a case whose reasoning was designed to protect, explicitly designed to protect the power of slave owners. So why do courts cite these old cases today? In part, I think citation can be explained by lawyers' habits. Lawyers rely on citations even for basic legal rules or definitions. Their opinions also give us hints as to why they chose these older cases rather than others. Finding early cases gives courts a chance to demonstrate their research skills. Some even draw attention in the text of their opinions to the independent research they undertook to find authority for the rule of law they sought. Such citations are also occasionally designed to honor tradition. In some of the cases I found, for example, judges draw attention to their citations of opinions authored by famous judges. So for instance, Nisbet's fellow Supreme Court Justice Lumpkin, I noticed at least one court said, hey, look, we found a Lumpkin opinion. We should cite that. Now, these practices trivialize the citation of slave cases. By choosing a slave case to define basic legal terms or demonstrate learning, judges show how lightly they weigh a case's slave context when deciding to cite it. Courts demonstrate an interest in legal traditions and history while obscuring the history of the people about whom these legal rules were made. They continue the dehumanization intrinsic to the law of slavery. So because this law of slavery is deeply embedded, right, it dates all the way back to Litchfield and earlier, it's not going to be easy to address. I suggest we look outside the legal system for models. Recent scholarly work has revealed the important role that slavery has played in many aspects of American society. And this work has revealed the ongoing legacies of racial inequality that slavery has helped create. So across the country, groups are confronting the memory and persistent influence of slavery's legacy. And these efforts illustrate the urgency of addressing that legacy. Now, based on these efforts, I've established some principles for addressing the legacy of slavery in law. First, I think we cannot eliminate the legal system's reliance on precedent and be impractical to stop citing all precedent authored by judges who engaged in bad acts. All 19th century judges benefit at least in some part from slavery, even those in the North. And certainly they benefited from other kinds of inequality as well. That said, I think we need to recognize the special harms of citing these cases. They were critical to a white supremacist framework that's opposed to basic legal values of fairness and justice. It's not just the authors, but the reasoning and language of these opinions that can be objectionable. For these reasons, we can't just treat these slave cases like regular precedent. Judges who nevertheless wish to cite these cases must at minimum address both the dignitary and legal harms that come with citing them. So I have some ideas for how to address the citation of these cases, which I'll share with you now. First, I think we can help lawyers recognize and acknowledge these cases by improving legal research tools. So they flag slave cases like they flag other cases with questionable precedential value. So right now, if a case is overruled, say Plessy v. Ferguson or something like that, there'll be a red flag next to that case. You as a lawyer know not to cite that or rely on it. But I think a symbol for slave cases would help acknowledge the prevalence of these cases and prevent accidental citation, and encourage legal researchers to read beyond basic legal holdings to consider the context of the legal rules they cite. Courts, I think, should also do their part by publicly acknowledging the legacy of slave law and by making that history accessible. The Georgia Supreme Court, for instance, should provide public resources that acknowledge the legacy of this law and make the history of it accessible to those who don't have access to the fancy legal research tools you normally need to see this stuff. I've also developed citingslavery.org, a website that will make this research accessible to the public so that they too can play a role in helping and forcing the legal profession to address its role in slavery. So I've recently applied for a grant that will hopefully eventually this database will contain not just the cases I cite in this recent research, but also an entire database of all 11,000 appellate cases related to slavery. Now, change may seem difficult, but it's not impossible. My third proposal in my initial article based on this research is that the Blue Book, which is the sort of legal equivalent of the MLA style guide or Chicago Manual style, require an additional signal, so a parenthetical statement after a case that was a slave case to say, hey, this is a slave case. Well, I approached the Blue Book, and this is going to be included in the next edition. So let me sum up. Near the end of his life, when Nisbet described his profession's development, he spoke proudly of the professional bar that he and his colleagues had built. Lawyers, he believed, came to success through hard work, diligent study, persistent energy, and integrity. They had developed an esprit de corps of kindliness as well as of pride and honor, and made the legal profession the most honorable amongst men. Northern lawyers, even those whom Nisbet might have termed members of the Radical Party, would have agreed. Legalism and the embrace of this routine commercial practice allowed them to work together and to agree on a conception of the profession's value and its services and its service of right and justice, isolated from its social and economic effects. My research reveals that the continued citation of slave cases then is part of a broader failure to grapple with the legacy of slavery, and with an approach to legal reasoning Reeve, Gould, Nisbet, and other Litchfield graduates have helped to pass on to their successors. Lawyers continue to abstract law from its context in ways that distort it. By adopting such a perspective, the legal profession has limited the potential for addressing slavery's legacy. Acknowledging and addressing the continued role of slave precedent in the American legal system, I think, is one step toward recognizing the role lawyers played in supporting society based on subjugation. Now, like the response to any atrocity, legal recognition of slave citation will be incomplete, and really it's just the first step. But I think the legal profession should take this opportunity to reconsider the myopic perspective that has led them to continue to cite slave cases more than 100 years after the ratification of the 13th Amendment. Only then, I think, can the profession truly say that it's striving for those values that Nisbet thought it had already reached in the 19th century. Thanks.
Justin, that was fascinating. Thank you. For our audience, feel free to drop questions you have either into the chat feature or into the Q&A. And to get us started, Pete has asked an interesting question here. Does the fact that the 13th Amendment's criminal exemption allows for involuntary servitude to continue in some cases contribute to the court's citation of slave cases?
That's an interesting question. I mean, what I found most of the time is that the courts don't acknowledge the 13th Amendment at all in relation to these cases. And I think actually there's been more attention in the legal profession focused on that criminal context and less focused on this sort of everyday commercial context. And so I think, you know, one of my hopes is that people who are interested, you know, there's been a movement recently to remove that exemption in the 13th Amendment for a variety of reasons, including abuses that prisoners are suffering.
Right.
And my hope is that people who are interested in that will also be interested in seeing the way that commercial law has also contributed to inequality and you know, racism in the United States.
Right, right. So just, questions are rolling in. So I'm wondering if, this is from Mark, he's wondering if you would be willing to discuss how this research informs the way you teach the course on professional responsibility.
Yeah, thank you, Mark. It's a great question, and thanks for coming. So professional responsibility is like the legal ethics course at the law school, and it's the only class that the American Bar Association requires every law student to take. And the way it's traditionally taught is there's a body of ethical rules that lawyers are required to follow, you know, stuff like don't steal money from your clients, keep your clients' information confidential, that sort of thing. The way I teach the class is I teach those rules because they're important, obviously, we need to follow them. But also I like to think more broadly about the way that we can become ethical practitioners. So we talk about issues of representation in the profession. We talk about the biases that women and African Americans and other minorities face in the profession. And I want students to think more generally, to have to be capable of taking a critical perspective on their profession. You know, and I don't want to come down hard on Reeve and Gould because they were doing what, you know, their best. And I think a lot of lawyers today are doing that same thing, like sort of, let's keep these controversial, difficult issues out of our classroom. And my hope is that by talking about race, talking about representation in my class, that's going to prepare lawyers not only to be ethical practitioners, and this is a case I'm trying to make to my colleagues as well, but make them better lawyers. Because of course, race, class, gender is going to affect how even if you're a lawyer for a bank, it's going to affect how you interact with people. And if you're not aware of that, I don't think you can be as good of a lawyer.
Yeah. All right, and we have another question here from Mary, who wants to know, what comes up in Westlaw Key Cite about the status of the cases? So is there a treatment code post 13th Amendment questioned even?
Yeah, no, and so there's nothing at all. And part of the reason so normally the way it works, right, is there's a case that overrules another case. The Westlaw people who, the researchers who filled this all in, flag the case and everyone knows about it. But the flags don't work as well for things like statutes and amendments, because when the 13th Amendment was ratified, you know, nobody at that time, they didn't think that the 13th Amendment should affect these other cases, right? Because of that legalist perspective. So nobody went back and flagged them all and said, hey, you should reconsider this. And so my hope is that if we flag these cases, then maybe that people will reconsider that. But yeah, it's a great question. I mean, right now there's no acknowledgement at all. So if you look at these cases that I cited, they're green symbol, and you know, unless you read more carefully, you might not even realize they're about they involve enslaved people.
Right, right. Another good question from Casey, who wants to know, have you gotten any pushback from the law community with this citing slavery project that you're working on?
Yeah. I'm not sure if you're a lawyer, or if you just have a good sense of what lawyers are like, but yes, absolutely. So my proposal to add this citation led to me being accused of wanting to, I guess I said I was canceling. I was part of cancel culture for legal opinions, which of course, I'm not saying no one can cite these opinions. I'm just saying if you do, you should read them and admit that they're slave cases, and then acknowledge the legal and dignitary harms.
Yeah.
But I've also encountered resistance from people who say that this kind of research and teaching doesn't belong in law schools. Lawyers are very, I would say, tend to be very conservative with a small c. So not politically conservative necessarily, although of course there are politically conservative lawyers, but the profession as a whole is scared of change. And this is part of the reason why nobody said after the Civil War, hey, maybe we should like really redo things, and why it took so long for the 13th, 14th, and 15th Amendments to really make changes in American society. So short, that's a long answer. Short answer to your question is yes, I've experienced pushback. I will say, on the other hand, though, that there are a lot of lawyers, judges, and especially law students who see the value in this work and have really encouraged me. When I first, actually, this is reminding you a little story. When I first presented this paper, I first presented a very early versions paper, and people said, oh, this is neat, continue working on it. I then presented to another group of people where one person stood up and said, who cares? Roman law involves slavery. Who cares? What's the difference? And and Roman law is like a very early precursor to a lot of American legal forms.
Right.
And and I was really down about it. I thought maybe this work doesn't matter, maybe people won't care. But then the next day I was going to teach students. I teach a class on law of slavery. I said, hey, you guys, let me just tell you something about this work I'm working on. Do you think this matters? And they all said, yeah, of course it does. Now, maybe it's because they wanted me to give them a good grade, but I think actually there is a recognition, especially of younger people who are interested in the law, that this is something that that we need to address.
Right. And I think especially for those of us not in the world of law and in this field, I think a lot of us don't even realize how much of laws being, decisions being made today are sort of rooted in this, in the law of slavery. So we do have another question coming from Sharon, who wants to know if you work with, and she's given us a website. It's case.law.
Yeah, actually, so Sharon, you've great question. And actually, I'm going to share my screen for 1 second to show you something else here. I actually have been involved with case.law from very early on in this project. So next thing I'm working on right now is studying the indirect legacy of slavery. So for every case that directly cites a slave case, there are many more that cite cases that cite slave cases. Right. So here's an example of what one of those diagrams looks like. So this slave case is only cited 3 times, but then it's cited, those cases are then cited many more times and more recently. Wow. So 2 degrees removed, slave cases are 2 degrees, sorry, that's too complicated to explain, but let me just say that this is the big number that's interesting. There are 800,000 cases, so 13% of American cases are within 2 degrees of slave cases. So either are a slave case, cite a slave case directly, or cite a case that cites a slave case. And the reason I'm able to do this research is because this new database, case.law, the Harvard Case Law Access Project, encourage everyone to check it out, has basically given away a lot of this stuff that's in legal databases for free. And they have some great tools for researchers, one of which is that allows me to analyze these citations. So let me just give you another example to sort of more visually describe what that looks like. these are 200 slave cases, which I randomly selected. And this is the second generation of cases. And these are the third generation of cases. You can see how quickly the law of slavery spreads. And here's one more example of what that looks like. The red cases are slave cases. And all of these black dots, along with these connections, are what's created from just those 200 slave cases. So,
so that number 13% that you had next to the number 800,000, what is that? Is that 13% of?
So that's 13% of all cases in the case law database.
All cases.
That's all cases. So 13% of all cases that they have in that database, which is pretty comprehensive, are either slave cases, cite slave cases, or cite a case that cites slave cases. So part of what I'm doing now is trying to figure out, how big that influence really is. How much has that shifted doctrine? Now it's hard to do, you can imagine, because cases that are a couple degrees removed, right? It's hard to exactly pinpoint how they've shaped the law. But, I think that number, to me at least, suggests that there's a lot that we're just beginning to scratch the surface of how influential these cases have been.
Right. I mean, it definitely seems that, it seems foundational, right? Like this is 13% that's a large percentage.
It's a lot of cases, yeah.
Based on, the fact that, on slavery, which is, which actually, this kind of leads me into another question. So talking about the implications on citing slavery, but are there other areas of the law where this is like that have like a similar issue? Other analogous, other concerns for other areas of law? Yeah,
I mean, I think certainly. I mean, and I haven't done the research here, so this is more speculative, but, there are a lot of cases, obviously, where terrible treatment of women, or where women, and this is something actually where Reeve was pretty progressive in his legal treatment of women, but he was in the minority. And so there are definitely plenty of cases like that I think would be very interesting to explore, in which women were essentially treated as the property of their husbands or fathers. There also are a number, of course, Native American cases in which there are horrible stereotypes, and those cases sometimes form the fundamental grounding of Indian law. Now, there are reasons to think that maybe slave cases are different, because it might be possible to avoid citing these cases, but maybe these Native American treaties cases are sort of the fundamental ones. Even if they're based on racism, you may still need to cite them. Now, that said, that shouldn't stop you from acknowledging that and maybe rethinking those doctrines that were decided by a bunch of people who are super racist. But yeah, I think there's a lot of interesting implications in other areas of law, for sure.
Right. Great, and just a reminder for our audience, feel free to keep up with the questions. But in the meantime, I'll just continue on with more questions. So your work connects historical research on race to the issues that sort of we are confronting today, about the erasures of past racial harms and subordination. So what role do you see for history in addressing systemic racial inequality today?
I mean, that's part of what I'm like excites me about this work, is that it's rooted in serious historical research, a lot of, some of which took place at Litchfield and with the Litchfield notebooks. And I think one thing that's cool about history is it has actual facts that we can use. So if you want to, go in and read the notebook and say, actually, it said this instead of that, that's something, we can have that debate. But I've done that and shown, the way in which is influential. I've read the cases. And so because of that, it's a lot harder to argue away than more nebulous claims, right? So someone says, these nebulous claims are maybe totally accurate, but I can say this is historically based. So someone says, hey, I think the legal system is biased against African Americans. there's lots of good reasons to think that, but history gives facts to back that up, to show that this method of legal reasoning, for instance, that Nisbet and many of his classmates used did result in a law of slavery that continues to be cited today.
Right, right. So I know this is only part of your broader research, but could you tell us how the history you use in this article fits with your other research on Litchfield lawyers and economic development?
Yeah, definitely. So my dissertation, which is a book manuscript and will get published eventually, soon, I promise, I trace a number of different Litchfield lawyers into different areas of the country and show the effects that the work of them and their colleagues had. So I follow some lawyers to New York City, where they played important roles for big business, for corporations. I follow other lawyers to the Western Reserve, Ohio, where their work played an important role in settler colonialism and in building sort of capitalism, moving or sort of expanding capitalism west. I had this chapter on Nisbet, which I've used portions of here. And I also have analyzed the work of lawyers in Connecticut whose early work helped to encourage transaction in the US. And so when I started this project, I never expected to end up writing so much about slavery. And I remember, and actually this is related to my first visit at Litchfield, I went looking at these notebooks. I'm not sure what I thought I was going to find, but I think maybe I hoped I would find like the secret to interpreting some clause of the Constitution. I definitely didn't find that. Instead, I found these notebooks that were full of this technical law and that had more in common actually with the way law schools are run today than I expected. And so I wanted to figure out why people from all over, who then went all over, wanted to come to this school up here. And that's what led me to this. It turned out that this commercial law was really useful. And so it was useful in all these different locations. And so the law of slavery was just part of this broader constellation. And, and this work wasn't all, doesn't all have this negative moral tinge. I would say that the work, for instance, of the lawyers who are helping to make promissory notes function in Connecticut played a really important role in developing the economy before cash was really widely circulated. So that's a preview of my book.
Oh, excellent. Well, we're going to want that one too when you get it. All right, so we do have just a couple more questions. And our next one is a provocative question. I say that right up. So I'm just going to read the question, but so property is property. Should precedent and case law be discarded because we find the nature and definition of property discussed in the early 1800s despicable and morally wrong? Don't the fundamentals hold?
Yeah, so it's a great question. And what I'm saying is not that we should necessarily discard the fundamental doctrines of property or of contracts or all these other things that are related to the law of slavery. What I'm saying is that we should at least double check. Right. So I found a few examples in which judges cite. So, for instance, that tire shredders case that I started with. Yeah. The judge cites that case and says, well, we're not going to follow that case because it didn't involve commercial property that was difficult to replace. But anyone who knows anything about slavery would realize that enslaved people were considered commercial property that was difficult to replace. So I don't think that my work necessarily calls for a wholesale reimagining of the property regime, although you could make that implication. But at least at first, what I'm asking for is for us to reconsider these legal and dignitary harms that come from directly citing those cases. But thanks for that question.
Yeah. Okay. Ooh, more questions coming in. Another interesting one from Mark, who starts it off not to be an accidental Litchfield apologist, but he's actually looking at sort of the inverse of things. And Litchfield's training, do you know if it inspired any anti-slavery law?
Yeah, it's a great question, Mark. And and
both sides of the Amistad.
Right, the Amistad case is a perfect example. And that's sort of what I initially thought I would find in the notebooks. But I think there's nothing in the notebooks that necessarily translates to that. I think that that's more relates more to actually what you've written about, which is the way in which Litchfield society and those communities kind of help to, build a culture like that. And I don't think Litchfield prevented people from doing that, and in the same way didn't prevent people from, it's sort of like what law schools do now. This is a better way of putting it. They give you a tool, and how you use that tool is in many ways up to you. And I think some people were certainly inspired by Reeve's example to advocate against slavery. Horace Mann's another great example, but at some fundamental level, the legal culture at Litchfield didn't demand that. It said it was okay to be a lawyer who worked for slavery. That's just part of being a lawyer. And that's very similar to how lawyers view themselves today. But thanks, great question.
Right. All right, just a couple more questions. This is not a question so much as a comment coming from Whitney, but I think it's so interesting that we should share it. Who writes, the other way Gould gave ammunition to lawyers looking to secede was his regular comments that any law could be repealed. And of course, repealing laws was part of the Southern strategy to avoid being part of the Union.
And actually, it's interesting, as I mentioned, great point. Nisbet drafted the secession ordinance, and he wanted to be written in a very specific way to make sure it was legally made sense, which I think is being lawyerly as you're seceding from the country is a very lawyerly thing.
All right, just a few more. Mary asked if this is going to be recorded, and the answer is yes, we are recording, and she wants to share it with the American Association of Law Libraries.
Well, actually, a plug for you, Mary. I'm going to be presenting on a panel about this Blue Book rule change at the American Association of Law Librarians Conference coming up. So I hope to see you there.
Awesome. And yes, we will be making this recording available for folks. So definitely, if you know people who didn't make it tonight, share. And
also one other note on that, I'm always happy to hear from people who are interested in this project or working on similar stuff. So please feel free to reach out, anybody.
Yes, and I will, I did want to put a link to your Citing Slavery website in the chat. So while I'm doing that, we have one final question. I thought I would leave a good one for the end. This question comes from our archivist, Linda, who wants to know whose notebook was your favorite and why?
Oh, I can't pick my favorite notebook. That's like asking me to pick my favorite child, Linda. I can't be put on the spot like that. I will say that I think they are, way more people should be reading them. They're really fascinating, and there's so much in there. And the cop-out answer also is the ones with the best handwriting.
The best handwriting.
Were my favorite.
Right. Remember that, school kids who still write.
Yeah, learn how to read cursive if you want to be a historian.
Yeah,
very useful.
Learn to read cursive and keep legible notes. Some more lessons for today. All right. Well, it looks like we have we've had answered all of our questions, and folks are saying thank you, and we're wrapping things up. So Justin, I just want to again thank you for sharing your research with us tonight. I know I've learned a lot. I think other folks have as well. And as always, it was just really fascinating. So thank you very much.
Thanks. Yeah, it's a real pleasure to be invited and reminded of where this work really all started. And like I said, it was a circuitous route, but yeah, I'd not be here if not for Litchfield. So,
well, hopefully sometime in the future we can have you back to the museum, where you can arrive in. I don't know, how will you arrive next if not like broken down motorcycle?
Yeah, I know. I have a lot to live up to. A hot air balloon or something.